HMRC guidance, which was correct, still accurate still up live as of yesterday, was to be eligible for the grant, employers must confirm in writing to their employee that they've been furloughed. If it's done in a way that's consistent with employment law, that consent is valid for the purposes of claiming the CJRS. There needs to be a written record, but the employee does not have to provide a written response. So the two, as you can see, are completely at odds with one another. The direction says you need the written consent of your employee. The guidance says that you don't. So what's the approach you should take to this first obstacle? Well, I think it's pretty clear that if you've got an employer who's asking you for advice who has not yet furloughed their employees, then they should be careful to comply with the direction. What they would need to do is ensure that they obtain the written consent of their employee in order to comply with the direction that's sent out by the Treasury. That's the more straightforward of the two positions. The more difficult position is if you've got an employer who's already furloughed employees in line with the previous guidance and the current guidance, which says you don't need to get written consent. I've checked this quite carefully, and again, helpfully, there seems to be conflicting views on the approach to take when you've got this. I know that certain large firms of solicitors are taking a much more cautious approach and are saying you should go back and get retrospective written consent from everybody who you've furloughed, regardless of the situation, regardless of the guidance. A lot of you may subscribe to Daniel Barnett's employment update. He takes a much less cautious view of this. He says, don't poke the bear, essentially. He says there's no way HMRC will refuse to pay you out under the CJRS if you've not got written consent. They would be open to judicial review if they did so. So just carry on as normal. I'm going to take a moment to get plenty of splinters in my backside by sitting on the fence. My advice to take would be, it will depend on the situation you've got with your individual employee. Your employer clients will know how they're best suited to deal with it. If they've got a good relationship with their employees and they think that going back and getting written consent is not going to cause an issue in the employment relationship, then I think it's appropriate to go back and do that. On the other hand, I think if you've got an employer who thinks we've got employees who are a bit tetchy, relations are bad, this is going to wind things up and potentially cause issues, then it might be better to leave it, because I do think that HMRC would leave themselves in some difficulty if they started refusing to pay out under the scheme if they've produced 6 versions of the guidance, none of which say you need written consent. Moving on then to deal with consultation. The best advice I could give in this situation is treat advising on any decision to furlough like you would a redundancy, and approach it in that way. So this is a serious change to the employee's terms and conditions of employment. It's almost inevitable that you're going to need to adequately consult them before doing that. If there's a union that's recognised in the workplace, employers ought to be looking to involve them as a matter of best practice. Similarly, if there is a situation where you've got employers who are having to select employees for furlough and leave some of them at work, then again, the advice would be to treat it as if you were dealing with a redundancy selection exercise. You want objective criteria for making the decision, and ideally a record of your objective reasons for selecting who has been furloughed and who has not. Failing to do that could leave you vulnerable to either a breach of trust and confidence claim or a discrimination claim from employees who are either not furloughed but who want to be, or who are furloughed and don't want to be. Next up, on the topics is the issue of furlough and remuneration. What exactly is the employer required to pay, and what can they recoup from the CJRS? Well, the primary consideration is you've got to look at what the employee's statutory rights are and what their contractual rights are. Just because the employer wants to furlough doesn't mean they can unilaterally change what is in the contract of employment. So unless the employee agrees otherwise, you've got to pay them what they are entitled to by statute and in their contract of employment. The CJRS is a scheme for reimbursing employers. And so any calculations in relation to that are great for working out what the employer is going to get back out of it, but don't make a difference to the employee's pay packet unless they agree to a change to it. If the employer unilaterally changes things, they're going to be open to an unlawful deductions claim. In terms of what's included for this recouping from the CJRS, the direction, the relevant bit of the direction is paragraph 7.3. What that says is that an employer can only be reimbursed for regular salary or wages, and anything that falls outside the definition of regular will not be reimbursed. I've set out in the handout what paragraphs 7.4 and 7.5 say in terms of what is regular and what isn't. And it seems to be, again, as a rule of thumb, anything that the employer is obliged to pay, then that will fall within the class of regular salary or wages. Anything that seems to be discretionary or dependent on somebody else, so sales-based commission, performance-based bonuses, tips, whether they're paid via trunk systems or otherwise, the guidance seems to suggest that they should not be included for the calculations in relation to the CJRS. If you've got the last sort of little quirk is, if you've got an employee who is due to return from maternity leave and then go on to furlough, the salary for the purposes of CJRS would be their pre-maternity or paternity leave salary, not any lower statutory sum whilst they were off on maternity or parental leave. Again, this is an area where, unfortunately, the guidance produced by HMRC is relatively unclear. And I think they're going to have to produce further clarification at some point in the pretty near future. Lastly, just tying up some bits around annual leave, sick leave, and maternity leave. Holiday pay is probably the most complicated, not least because the direction that's been produced by the Treasury is completely silent on the issue of how holiday leave interacts with furlough. But as far as we can tell, 1, employees continue to accrue annual leave as normal during furlough. 2, employees can take their holiday during furlough, and they must be paid by the employer normally as they would have been for holidays. The employers are entitled to be reimbursed, but only up to the cap. They will have to top up the rest when the party takes holiday. Of course, because the leave that is covered is Regulation 13 leave for the working time regs, that holiday pay that is topped up to will be the broader definition of holiday pay that the ECJ cases and Locke have suggested. Employers can, if they want to, force employees to take their holidays during furlough, provided that they comply with the notice requirements. In relation to this, the working time regs have been amended so that you've now got 2 years in which to carry over your regulation 13 leave. That's your first 4 weeks of holiday from the end of whatever your agreed holiday period is. That doesn't apply to regulation 13A leave, but that can be carried forward by a year with agreement between employer and employee. The thing that's currently not clear, and again, there seems to be a difference of opinion on, is whether taking a holiday will interrupt the minimum 3-week period for furlough. I've read different people saying different things about it. Until we get some more guidance, I would be advising employers to take a cautious approach in relation to that, and not risk letting leave go ahead and interrupting the 3-week period for furlough. Sick leave. The big question is, can you have SSP and furlough and be furloughed at the same time? The answer is no, you can't. You can either have an employee who is on SSP, or you can have an employee who is furloughed. You can't have both. It's up to the employer. This scheme is gives the discretion of the employer as to which one they put the employee on, but they've made very clear that people on long-term sickness absence can be furloughed if you decide to do that. Lastly, maternity leave. Normal rules for maternity pay apply. An employer can furlough an employee on maternity leave. The employer is obliged to continue paying them their contractual or statutory maternity pay at the rate they're entitled to. I think from the guidance, there appears to be a separate fund from which maternity payments can be claimed, but they will at least get the 80% of the salary, if not more. Last important thing for advising employees, it is possible, if they're a gambler in nature and they're in a position where they're on statutory maternity pay and their 80% furlough pay would be higher than that, they can choose to end their maternity leave, be furloughed and take 80% of their salary, but that's relying on the furlough scheme being extended beyond its current date. And if the scheme comes to an end before then, they cannot go back onto maternity leave and claim statutory maternity pay.
And you'll see I've given a fairly detailed handout, which is in the bundle of documents you've been given. And it starts at page 17. So I'll give you all a moment to turn to that if you're not already there. You'll see that the two decisions which I'm referring to were handed down actually earlier this month by the Supreme Court. The first one being the case of Morrison's Supermarkets and various claimants. The second one being Barclays Bank and various claimants. So two, we can see large PLCs involved in these cases. And the reason I think it's really quite interesting, I think is probably summed up by Lady Hale's comment in the opening paragraph of the Barclays Bank judgment. And I've set it out for you there at paragraph 2. But really what she's saying is the law of vicarious liability is on the move. And these two decisions really help us try to identify how far that law of vicarious liability is actually on the move. And it struck me as interesting because I think as employment lawyers, whether we're acting for claimant or respondent, we can be almost complacent sometimes in seeing that, well, if something's done by an employee, then it must therefore have been done in the course of employment, and it must therefore mean that the employer is liable. Now, it's of importance to claimants to realise the extent of this law because they might, for example, want to make more than one party a respondent to any claim they make. But likewise, it's important for employers to understand because they may actually have a defence to a claim where they otherwise didn't think that they did. So I think it's really important for us to look at these two decisions, and I've tried to do that for us. The first one I've set out is the case of Morrison's, and I've given you a short summary of the facts, paragraph 5. We're all probably quite familiar, at least in the abstract, with this case because it's the one where there was a substantial data leakage by an employee of Morrison's. And we all know who Morrison's are, I imagine. And we can see that in the case it was explained that they have over 9,000 employees and that there was someone who I've called Mr. S for the purposes of my handout. I think he is named in the judgment, but I'm being cautious. He had been subject to disciplinary proceedings for minor misconduct, and it turns out that he held an irrational grudge against his employer. Nonetheless, as part of his employment, he was delegated the task of collating and transmitting data for the purposes of an audit. Indeed, in order or to enable him to carry out that task, he was given by his employer access to the payroll data of a substantial number of employees, their names, their addresses, their gender, their date of birth, for example. And all of that was provided to Mr. S in order for him to carry out his tasks as being an employee of the respondent, in this case, Morrison's. Lo and behold, what this individual did, perhaps remarkably, you might think, he managed to transmit the data to a USB stick. He obtained a pay-as-you-go mobile phone. He made up an email address under the name of a colleague who I think it transpired he was looking at, in essence, to frame. And then he provided various of this data to newspapers. Now, thankfully, one of the newspapers had the good wherewithal to get in touch with Morrison's, and Morrison's then dealt with it. The big issue that arose in this case, though, was one of vicarious liability, because various claims were made for misuse of private information, breach of data protection, and breach of confidence. And it pursued its way through the courts, all the way to the Supreme Court. At first instance, it was Langstaff J who actually rejected Morrison's argument. Morrison's, of course, denied liability on the basis that they weren't vicariously liable for the actions of Mr. S. High Court disagreed. They said, actually, well, do you know what? Despite what he did and despite his motives, what he did was closely related to what he was tasked to do. There was, in the High Court's view, a sufficient connection between what he did and his employment with Morrison's. It went to the Court of Appeal, and lo and behold, the Court of Appeal agreed with the High Court. They said, and I'm paraphrasing here, they considered that the acts of Mr. S were within the field of his activities assigned to him, and that there was a seamless and continuous sequence or unbroken chain. And they went further and said that his motive didn't matter. So both the High Court and the Court of Appeal determined that actually Morrison's were vicariously liable. Now, pausing there, on the string of authorities and the case law as it stood prior to that, one can actually see, I think, why the High Court and why the Court of Appeal came to that decision. But I'm sure you might all agree, it leaves a rather, I say, sour taste in one's mouth to think that Morrison's could be liable for the actions of Mr. S in those circumstances. And so we get to the Supreme Court. And in the Supreme Court, the Supreme Court, doing as it does, they took a very detailed review of the earlier authorities. They said that the lower courts had actually taken out of context some of the earlier guidance, and some of the things which they found were of particular importance in their decision are the things I've set out at paragraph 7C of your handout. And in there, I make reference to paragraph 31 of the judgment. And some of the things they found in particularly important, and I'm going to highlight just a couple for you. They said that the disclosure on the internet did not form part of Mr. S's function or field of activities. It was not an act he was authorized to do. They said that whilst there was a temporal link or an unbroken chain between his obtaining the data as an employee and his then posting it elsewhere, that was not in itself sufficient to establish the close connection test. And they actually vehemently disagreed when you read the judgment with the Court of Appeal and the lower courts in saying, they said that the reason he acted, his motive was entirely relevant. It was evidence of the fact that what Mr. S was doing was not for the purpose of the objective of his employment with Morrison's, but rather for his own personal gain, his own personal vendetta, it seems, on the reading of the judgment. The ultimate question that we are, or what we are told by the Supreme Court we're asking ourselves, I've set out at 7D, and I think it's worth looking at it. The question was whether Mr. S's disclosure of the data was so closely connected with the acts he was authorized to do that for the purposes of liability to his employer or to third parties, his wrongful disclosure may fairly and properly be regarded as done by him while acting in the course of his employment. Now, my own view on that is I think that's a bit of an extension of the law as it existed before. I think that this actually makes the law rather more favourable to employer than employee than was previously thought. And I'm going to make some comment on that at the end. But I think the Supreme Court actually went even further in their decision, because of paragraph 47, they said, the Supreme Court, they took the view that Mr. S was not engaged in furthering the employer's business. Now I pause there because to my mind, that is an extension in the direction of employer-friendly employment law. Because imagine this, whilst these cases aren't, for example, directly under the auspice of an Equality Act claim or a discrimination or harassment claim, but one can easily see how this might actually change our way of thinking. For example, what about the employee who sexually harasses or discriminates against someone in the workplace? Can it properly be said that that employee is engaged in furthering the acts or the objectives of the business? Can it be said that they are acting with their employer's authority to do those acts? But you might think on a literal reading of that, well, of course they're not. So how can the employer be liable? It's going to take some cases, I think, to test that theory, to see how far actually the law has gone on the move, as Lady Hale said. The second Supreme Court case, which I'm going to probably trot through slightly more rapidly, is the case of Barclays Bank. Now, this one is a slightly different point, but one we should be aware of nonetheless. This is a case which deals more readily with the question of whether or not there is an employer-employee relationship at all. Not the question necessarily of, well, if there is, should vicarious liability be imposed upon the employer in that relationship? The facts I've set out very briefly for you at paragraph 8 of the handout. In short, this is quite a serious case actually when you read it. There was a Dr. B, who allegedly committed sexual assault for over a substantial period of time on some 126 claimants, females. He was a medical practitioner who Barclays Bank had used in order to do examinations on employees and prospective employees. Barclays chose him, Barclays gave him the instruction, Barclays paid him. And indeed, you might find rather unusually that the examinations were undertaken in Dr. B's home, I think in many of the cases. So the question in the Supreme Court, again, the High Court and Court of Appeal being overturned by the Supreme Court, was whether or not there was a sufficient employer relationship in order for Barclays Bank to be vicariously liable. Now, in this case, the High Court said, yes, there was. Court of Appeal agreed and said, yes, there was. But lo and behold, we get to the Supreme Court and the Supreme Court disagrees with both and finds that there isn't a vicarious liability upon Barclays Bank, in that they find, and I think this case, when you read it, and it's essentially do read both, I think it leaves a lot to be desired, because as employment lawyers, our immediate reaction when we're thinking about an employer-employee relationship is to look at the usual things we would look at, like control, mutuality of obligation, financial arrangements, etc. The key things being control and mutuality of obligation. But the Supreme Court touches upon that, but then proceeds to tell us, well, actually, it's almost like putting a bit too much of a straitjacket on this if we go down the employment law thinking route. And they don't really give us much more guidance than that. They were able to tell us in the Supreme Court, however, that the details lie in the nature and the understanding of the relationship. Can anyone tell me what that means? Because I'm not so sure that I understand what that means. And it says that the real question is whether or not the person and the employee and the employer are in an employment relationship or one which is akin to employment. Again, as employment lawyers, this all probably feels like rather unusual language to us, because I'm not quite sure what akin to employment means either. You're either an employee or you're a worker or you're something else. But again, the Supreme Court doesn't really answer that question. But what it does tell us, I think, in combination with the Morrison's case, is that the law really is on the move, and that for employer and employee, we need to really be rethinking sometimes our advice, because it might well be that there is an argument there which wasn't previously there in terms of vicarious liability. I've tried to give you some comments, and I'll be relatively brief. I think I've got a couple of minutes. At the end there, from paragraph 11 of the handout, and I've talked about the Equality Act, and I've talked about these cases in the context of the Equality Act. What I haven't done, and one must remember, is the reasonable steps defence, if argued properly and if properly evidenced, is always available to employers. But I also mentioned the fact, and I said at the beginning of this seminar, I was the light relief from COVID-19. I'm afraid I've managed to get a COVID-19 related issue into my handout, and it's this. When you've got employees who are home working, and they live at home, the question then becomes, well, where is the line drawn between someone being in the course of their employment and not in the course of their employment? When they're working and living from home, they might have unusual working hours. They might have to, because of COVID-19, for example, have to alter their working hours or be a bit more flexible. If that person does a wrongful act, commits an act of discrimination or an act of harassment during that time, where is the line drawn? And that, I think, becomes really fact sensitive, particularly with this new guidance from the Supreme Court. In any case, and to finalise, it's important for all parties to think about vicarious liability. As an employer, it's really important to consider it, because once you start running those arguments, I think there are important industrial and policy considerations to take into account. In particular, if you have one or two of the employees in the relationship still employed, you need to look at what your internal procedures have said, because it might end up that they become parties to any claim, and it could sour the relationship between you and that employee. So it's really important to think about all of that. But in the main, the purpose of this handout is not to give you, I'm going to give you the usual barrister caveat that you get with these things. It's not to give you a blanket advice, but I do hope that it's managed to perhaps open our way of thinking a bit when it comes to vicarious liability. And who knows, the Supreme Court may well, particularly for employers, have even given you a route out of some cases. I hope you've enjoyed that. I'm hopeful that there are some questions and answers. We'll be happy to answer them at the end. Thank you, and stay safe.
My talk today is really going to be more practically based, but it does raise the issues about addressing your mind in terms of policy and procedures, even though this has come into being very quickly and without much planning or warning. It's true to say that there is no statutory definition of a home worker. So we're working away here with the usual concepts of employee and worker. The Office for National Statistics in December 2019 estimated that there were 1.7 million people working mainly from home, which is about 5% of the working population. It went up to something like 30% when you took into account people who worked from home from time to time, or even on a fairly regular basis. So it may well be that many employers will already have addressed the issue of home working in policies that they have in their manuals. But here are the important points then from a practical legal point of view, and my handout sets them out from page 29. So I'm just going to very quickly go through the main things which I think in essence are health and safety obligations. Now, quite clearly, when the lockdown happened, it was quite a sudden event. We all knew that something was going to happen, but we really didn't have much time to plan. So the idea that employers have done risk assessments of each individual employee's home is going to be absolutely ridiculous. So what do employers need to turn their minds to? Well, clearly the duty in respect to take reasonable care of employees' health under Section 2.1 of the Health and Safety at Work Act still applies. And the Health and Safety Executive have a very handy online checklist for workers using DSE equipment, computer equipment, which may well be worth disseminating and highlighting to your clients that is something, it's a useful basic assessment tool that they may wish to access and use. There's also a question of effective communication when dealing with home workers. So the questions that employers need to ask they are to be directed to employees themselves. So ask them about how they're managing with their working environment, what problems they have. And certainly within my own experience, I have come across the situation where someone was working with a totally impractical ergonomically workstation. So it may well be that some employees will need particular assistance in sorting out a place to work at home, which actually meets their needs ergonomically. And the fact that they may well have a designated place of work in their home may help them deal with stress management, delineation as much as one can organise it between work and the home. So the employees who are disabled may need to have access to their particular equipment. For example, if they've got a modified keyboard, or they've had a chair that is one that's been provided to them because they've got musculoskeletal difficulties, for example, or equipment of that sort, it may be that they need access to that in the home, and obviously that can be made available to them if at all feasible. So these things need to be considered and built into the employer's approach. Reasonable adjustments, obviously, we know, can encompass other adjustments, not only to the physical workstation, but also working time and those sorts of matters. And obviously those adjustments need to continue in the home working environment. The duty of on employers, as I have already said, does embrace mental health as well as physical well-being. So working time then needs to be addressed, because it's very common, despite some managers not believing it to be the case, that many people actually work beyond their normal working hours or work at strange times. So there needs to be a clear agreement about what hours and time of work the individual needs to be available to work. So that needs clear communication and managing of expectations going in both directions. So how does the employer ensure that people are taking the breaks that they should be taking? It's recommended that people working with display screen equipment have a 5-minute break every hour. And in actual fact, everybody who's desk bound should be getting up and moving around for 5 minutes every hour. That's really important for good heart health for everybody, but also for problems with eyesight and visual problems. People should be moving on to different activities to break the work up. So managing the working time, clearly there are the working time regulations which I've set out in the handout about breaks, the average overall working week, 48 hours. Many employees have probably opted out from that, but it still has to be dealt with. The break after 6 hours and so on and so forth. So those have to be addressed in a practical way in any sort of policy and documentation and communication with employees about it. So how does the employer make sure that those are put into place? Because it is an active duty on the employer. They can't just necessarily leave it to employees. And so to ensure that they are taking their breaks, there may be the need to have some form of timesheet or some sort of check on, say, email traffic, something like that. Something just to see that people are not working ridiculous hours or working at ridiculous times and do have proper opportunity to rest and recuperate from work. So despite what many managers may fear, I think the contrary to people skiving or not doing their work, it's the other way around, that employees may actually be overdoing it, and that has to be managed. So communication, setting out clear expectations, and so on and so forth. Then there is the vexed issue of managing home workers remotely. And again, this comes down to very practical approaches of being flexible in terms of managing people and being effective in communication. Clearly, when you are communicating with people by remote means, it does cause difficulty in ensuring that there is an effective communication. So this actually brings in good practices that we as lawyers have, which is actively listening. Listening to what is being said and, very importantly, to what is not being said. And managers and supervisors may well have to adapt and adopt some of those approaches. So what is being communicated obviously needs to be explored with the individual so that feelings can be brought out, which is so important to managing stress in the workplace. There is an ACAS guide on managing stress at work, and so that's something that employers can be pointed towards to assist them in terms of that. So particularly in these stressful times, and given that individuals may have people that are near and dear to them suffering illness, if not themselves, then there has to be flexibility in dealing with aspects of work. Clearly, the individual employees need to report if they are going off sick, and so you need to have the usual mechanisms in place. When the individual's working at home, they'll generally, if they are dealing with computerized equipment, they will still have the normal duty of confidentiality and data protection duties upon them. And the employer remains responsible for those, for the data that is held on the employees' computers. So the usual approaches in terms of policy and so forth needs to be taken into account. So I think I'll leave what I've set out in terms of confidentiality and so forth, as I've set it out in my handout. I think you're all capable of looking at that. One thing that I think we need to sort of consider if this is going to go on in the long term, because the talk is that this pandemic will not be just one wave, but may involve multiple waves of lockdown. And I've heard talk of up to 6 different waves. The Spanish flu pandemic, of course, involved 3 waves. So we all hope that the economy is going to come back after we're all released from this open prison. But we may have to go through redundancies in the context where people may have been working from home for a particularly long time, which makes redundancy selection something, if it's not a wholesale closure of the organisation, of course, but is rather a redundancy situation where selection comes into play, then of course place of work does come into the definition as I've set out in my handout. So I think thought may need to be taken into account, and in terms of how the approach is taken to that issue. And clearly, the managers making selections must put out of their minds anything like, oh, they weren't showing commitment during that time, when they might have, for example, been dealing not only with working at home, but having to deal with childcare responsibilities, for example. There may be a point there whether or not they should have been furloughed, but if they've continued working and balancing childcare commitments, then you need, the employers would need to be extremely careful that they're not bringing in assumptions and preconceptions into ideas of people not being committed to the work and therefore marking them down. The key to that is to have good, objective as far as possible selection criteria. And then I've set out in my handout issues about who's picking up insurances. Clearly there are these issues that need to be sorted out so that the kit is insured if it's your kit, that the data and paperwork is kept confidential, that if there is a contribution towards costs in the home, for example, that that is taken into account and the tax liabilities are addressed. And I deal with that in a short form in my handout.
This is intended to be a practical guide based in part on my own experience of remote hearings, and also the experiences that I've managed to crib off all of the other members of Trinity and a few other chambers I've been able to speak to about how they've been getting on so far. The reason for this talk was, I don't know who sent this question, but many of you attending may have received the flyer that was sent out advertising, amongst other things, this webinar. And we asked for questions that might be helpful in terms of answering them as opposed to the question itself. And the question was about how you could take instructions during the course of a remote hearing and or give instructions, because of course you're not there in the courtroom sitting behind whoever's presenting the hearing. And so trying to distill that, it seemed to me that first of all, we needed to look at what the different courts, and for our purposes, tribunals, are doing at the moment in terms of remote hearings. Next, then look at what's happening now, because what's being said by both the ETs and the EATs is, number one, what they're doing now, and number two, what they hope to do in the future. And those two things are not necessarily the same. And then any tips that I've been able to find from others would give myself, or where some recent guidance, helpful guidance, has been provided. So first of all, the judiciary has helpfully provided an online page that sets out all guidance in relation to COVID-19, and the link is there on the handout that's, I think, starts at page 41 of the handout that I hope that you've all received. And if any of you haven't, please just ping an email to Chambers and we'll make sure that you get it. From the tribunals, the most recent guidance, I think, was on the 16th of April. And at the back of the handout, you'll see that I've copied that and you've got it within the body of the handout, but they are putting it online as and when guidance is handed down from the presidents of the ETs and from the EAT. So in terms of what the guidance is at the moment from the EAT, all hearings at the moment have stopped. If you have a hearing in the EAT at the moment, unless you are told by the EAT it's going ahead, it's not going ahead. And what the EAT are doing is they're going through the list of hearings, and they are identifying ones of those hearings that they think may be practicable to hear online through some kind of virtual means. At that stage, all that they're doing is identifying that something that might be something that could be done online. Thereafter, the parties are asked to indicate whether they agree with that preliminary view of the EAT and whether they can put an electronic bundle together. If the answer to that is yes, the EAT then have the final word. If they decide, having received that a hearing can go ahead, then there will be, it's hoped, virtual hearings in the EAT. I'm sure many of you are aware of the position in terms of the judiciary's functionality for virtual platforms at the moment. When this started, I think it's right to say that really Skype for Business was the only virtual platform that was available. In addition to that now, through someone at the court services confirmed to me that what originally has been provided to the family court is now being provided to the employment tribunals and the EAT, and that's something called the CVP, the Cloud Video Platform. The Cloud Video Platform is something that's been developed by the court service and was intended for rollout, I think, in at least one, possibly more than that, years from now. It's as a result of the pandemic, that's been brought forward very significantly. There have been substantial trials of it on the Northeastern Circuit already to try and make sure that it can run as smoothly as it can. The functionality of it is better than Skype for Business, but as I understand it, it's still not quite up to what you may all be used to from using platforms like this, like Zoom. The alternative, of course, is what now I suppose is antiquated, by telephone, and the intention is that some hearings may go ahead by telephone. For employment tribunals, all hearings, at least in theory, up to the 26th of June, have been postponed. Now, I know that a number of hearings that I have in my diary between now and the 26th of June, neither I nor my instructing solicitor have heard that those hearings have officially been postponed. But the guidance says that they have been postponed. In due course, you should be receiving notification of that, and the intention is to list a preliminary hearing to try and make sure that as soon as possible, a way forward can be identified, which may or may not involve relisting it there and then. Wherever it's been postponed, and this was something which I hadn't picked up initially, the frequently asked questions guidance tells us that any need to comply with orders for a hearing that has been postponed is suspended. So if you have a hearing between now and the 26th of June with witness statements that are due in the very near future, on the basis of the guidance from the joint presidential guidance from the ETs, you do not need to provide your witness statements by that date, because at the preliminary hearing, you will be resetting all of the dates. So if you need justification for that, click on the link on this handout, go to the FAQs, and you'll find it there. Employment tribunals are keen to indicate that there is the ADR options available of both judicial assessment and judicial mediation. And at present, although training's being rolled out, the use mainly in this area, south of the border, is Skype for Business. There has been training, we know from conversations that we've had with the regional employment judge on Teams, and you'll be aware, I suspect many of you, that Skype for Business is being phased out in favour of Teams, which is a better online platform. So as I understand it, there is an upgrade taking place across the court service where Skype for Business is being upgraded in order to allow the judiciary to have the Teams software, and hopefully that will mean that that can also be used soon for virtual hearings. But at the moment, the vast majority of any kind of hearing, including all the preliminary hearings that are taking place for those hearings that have gone out the diary up to the 26th of June, is by telephone. And that's either by BT Meet Me, described as a clunky and unsatisfactory solution by a local employment judge to me very recently, and also by Loop Up. The difference being BT Meet Me, the tribunal seems to be dialing out. Loop Up is when they'll send you the codes to dial in. Glasgow and Cardiff are also piloting Kinley Cloud, which is another kind of virtual platform. So what we have then at the moment is a situation where the vast majority of employment hearings, and the position is slightly different outside the employment jurisdiction, but employment hearings predominantly at the moment are going to be by telephone and then potentially with the idea that you then may set up a virtual hearing that may be through one of these virtual platforms if possible. That both the regional employment judge and the president and assistant president of the tribunals in Scotland have indicated to us that they are extremely keen to try and get these virtual hearings online. And the other thing which they've indicated, which I think gives an understandable indication that their approach they want to be that they want to walk before they run, is that the view is that public preliminary hearings are the ones that are likely to be listed for virtual hearing first. So wherever you have time point hearings, strikeout hearings, costs and the like, they are far more likely to be seen as suitable to try for a virtual hearing than, say, your 5-day discrimination case with a number of witnesses, where it's, I would suggest, on what we're hearing, more likely that that will be relisted after the 26th of June, at least as things stand at the moment. So tips on remote hearings then, that the first stage is really telephone hearings. The biggest problem with telephone hearings, of course, is taking some kinds of instructions. It's important to note that the tribunals are saying that they understand that a number of parties will need to dial in. So don't think that you need just one number to be provided. More than one can be provided. They have the capacity to dial in a number of different participants. You can be there both yourself, your lay client. If you instruct counsel, counsel can be in attendance in addition. But the reality is, and this goes some way towards the question which triggered this talk, that there are different methods to allow communication. I know, because of a case that I'm involved in, that for BT Meet Me, the judges are amenable to the idea that they will just have to let people dial off, have a separate conversation, and then agree between everyone that they'll dial back in by a particular time, so that that kind of instruction taking exercise can take place. And they're going to try and facilitate that. That of course, it gives very clearly the flag to how clunky that can be. And so in my view, and what I'm doing for a judicial mediation on Friday that's going to be through BT Meet Me, is that we're setting up a separate platform to allow us to communicate at the same time as the communications with the tribunal for the mediation itself. And I think at the moment it's very likely that we're simply going to use a WhatsApp group in order to send communications between us. But for WhatsApp, you can read any other kind of messaging system, you can use email, it doesn't really matter. Now, one thing that I do think is important though, if you are doing that, particularly if it's a substantive hearing, then you need to be letting the tribunal know that you are using that in addition, not least for the situation where you're likely to be taking instructions from someone who may be a witness in the case. And clearly, when that person gives evidence, if it's through a virtual hearing, they are going to need to confirm that they don't have any kind of, not only documents in front of them other than potentially a copy of the bundle and their statement, but also that they don't have any kind of communications mechanisms to allow them to be prompted. And one of the things that comes in once you get outside telephone hearings is, as you can all see, and I'm glad to see you're using it, some of you, for the Q&A system, and there's the chat function, you can send private messages and the like through a lot of these platforms. So that's something which will need to be policed quite carefully when virtual hearings are taking place, because there is the obvious potential facility for someone to send a private prompt to a person giving evidence. Now, the other thing that I want to flag to you is, in my experience so far at least, judges are being very sympathetic to the strange world that we've all found ourselves in. And so an example of that is, I was doing a hearing yesterday that was by Zoom in a disciplinary commission hearing. And the judge in that hearing got a doorbell being rung downstairs because some post was being delivered, and he simply paused the hearing and went off to get whatever the parcel was. They understand, and it affects them too. Sometimes you'll have the child coming in, sometimes the door will go. As long as everyone's sensible about that, it seems to me that at least so far, there is a sensible reaction from the judge. It's probably quite likely the judge would react in a sensible way when it was his own problem, but I think that would have been the same were it one of us that was facing the issue. So for video hearings or virtual hearings, we've actually had some guidance now. There's guidance direct from the presidents of the joint presidents of the ETs, and that's set out within the handout that you've got. That's in the FAQ document, which I mentioned was available online earlier. One thing which I thought was probably the most useful exercise yesterday is that it's terribly easy to forget to mute your microphone when you're not the person speaking. And if you've got a hearing with 3 or 4 people in it and going upwards, and 2 or 3 of them do not have their microphone muted, it confuses the kind of software that's involved in these virtual platforms. Because the way it works is that they're always trying to identify the speaking party in order to use the microphone from that party. And if there are noises coming from various different users of the system, then it will jump around and it can affect the sound quality quite significantly. There are obvious bits of guidance like trying to find a private room. In my case, trying to ensure that the children are locked as far away as possible from that private room, although they're likely to get out during the course of the hearing. But a lot of these are straightforward. One thing which is there on the FAQs, which I think is probably worth remembering, is you cannot record these hearings. And it's important that these hearings very often will be recorded. The party recording them should be the party providing and hosting the hearing on behalf of the tribunal. If they aren't able to do that, then you need to make sure that there is an agreement if there is an intention to record, in order that you don't fall foul of potentially inadvertently committing a criminal offence. We've all heard some stories about how it's been going so far in virtual hearings. Some I suspect true, some not. I thought I'd provide within the handout, hopefully for a bit of light relief, something that I found from a judge on the 17th Judicial Circuit in Florida, so not in these parts, but entertaining nonetheless. And he felt obliged to write to the lawyers attending his court, saying one male lawyer appeared shirtless, one female attorney appeared still in bed, still under the covers, and putting on a beach cover-up won't cover up that you're poolside in a bathing suit. So please, if you don't mind, let's treat court hearings as court hearings, whether Zooming or not. And I know that there have been, in this jurisdiction, the odd occasion of phone calls being done from bed, for example, where that has gone very directly. Don't want to put themselves up at bed in order to deal with the hearing. So conscious of the time and dealing quickly with some of the tips which are set out there, I don't think that you can conduct a virtual hearing easily without at least 2 screens. I know that you can split screens, but the reality is if you don't have an additional screen where you're able to have your documents, it's very difficult practically to make that work when you're actually working your way through. You will need to probably in these days have a PDF reader that's more advanced than the basic Adobe PDF reader, in order that you can bookmark documents, create e-bundles, and you can easily navigate your way through trial bundles. There are more basic things that are even before that stage when you're being asked whether it's possible to have a virtual hearing. I've got a 5-day trial that was coming up where we cannot have a virtual hearing because 2 of our witnesses don't have a computer, don't have the internet, and have no intention of getting one because of the coronavirus pandemic. That's fair enough, but it means that they're going to have to wait for their hearing to get heard. So make sure that there is the functionality to have one amongst those on your side as early as you can. And in addition, make sure that once you've done that, everyone has exactly the same thing. Now that includes things like trying to make sure that everyone has exactly the same pagination. It's really clunky if the electrical pagination of the bundle is different to the pagination at the bottom of the page. You inevitably end up with some people working from what's on the page and some people working from the pagination that's on the bundle. So try and make sure that they are one and the same. Like with telephone hearings, try and sort out how you're going to carry out internal communications. It's possibly easier, as I was saying earlier, because of the chat functions that you have with many of these platforms, but I don't think that those chat platforms are available on Skype for Business, for example, or at least not easily available, and that can cause issues with this kind of when we first started doing mock hearings to look at the functionality, we all got quite carried away with the fact that you'll all be able to see, I think, at the bottom of your screens, the share screen option. We thought it would be a good idea to share documents from the bundle to show witnesses. But when you strip that back and have a think about it, when you're in an employment tribunal, you do not stand up with your bundle and take your bundle over to the witness and say, here, look at this page, that proves my case, because they've got exactly the same bundle in front of them. So there's no reason that because you have a clever function that says share screen, you should ever actually use that in a hearing. Ideally, you will have the witness turning to the particular bundle page themselves. Maybe in a situation where they're having difficulty finding a document, share screen might become useful. A couple more things, and I'll move on to allowing us to get through some of the questions that have been asked. Not listed there, but I think very important, is look at the camera. When you're doing any kind of virtual hearing, the temptation is to look to the images of the people that you can see. So I can look to Steve or Jane or Andrew, and all of that means that I'm looking away from my actual audience. So ideally, identify exactly where your camera is and try and look at that camera for as much of the time as you're able. Now, of course, in any hearing in court, we're not looking at the judge or the witness all the time. We do have to look at our notes, but where you can, look at that camera. One other thing that I've learned from recent hearings is, particularly in things like application hearings, it's useful to have a scenario where if you have a problem with the connectivity, or if you want to interrupt someone, that person just puts their hand up. It's not like being back at school. It's just much easier than trying to find the button on these systems that allows you to put your hand up. And then the judge is alerted to it and can say, I think Mr. or Mrs. So-and-so has something to say. That worked extremely well yesterday in a hearing that I did, and allowed us to avoid the risk of over speaking, which is always present once you get lots of parties in a virtual hearing. I've given you the connection to the Inns of Court last week produced some guidance in relation to remote advocacy, and that's also very helpful. If you look carefully at it, you'll see that not all of it is entirely consistent with what the presidents of the employment tribunals think is the correct way to do hearings, but I'll let you spot that for yourselves. And last of all, it's very easy in these times, and we're really conscious of it, to feel isolated. But because we're self-isolating, it doesn't mean that we are in fact isolated from one another. We're all very happy to be available on the end of the phone, through a video link like this, to speak about kind of legal issue, or simply to catch up, and to make sure that all of us remember that once we get through all of this, we're ultimately a local legal community, and there are things other than Skype hearings that exist between us. I hope that was useful, and I look forward to seeing if some questions have been raised while I was going on.
So I think the first one we've got is probably for Andrew Crammond, and it says, regarding vicarious liability and the reference to discrimination, Do you consider this will change the interpretation of the statutory defence to harassment?
I must admit, I don't think it will, and my reason is this. The issue of vicarious liability under the Equality Act, I think, is two separate questions. First of all, there's the question of whether or not something occurred in the course of that employee's employment. And then secondly, the second string to your bow as an employer is the statutory defence, i.e. the reasonable steps defence. So even if they were acting within the course of their employment, did you take all reasonable steps in order to prevent them from carrying out the type or the act of harassment? So I think actually that the two cases I outlined earlier are slightly different to the reasonable steps statutory defence points. So sadly, I think the answer is probably no to that question.
Thank you, Andrew. Right, the next one is probably for James. If whilst on furlough, an employer goes through a fair redundancy process and gives the employee notice of redundancy, can the payments from the government under the job retention scheme be used towards the employee's notice pay if they are working their notice period, except that they are on furlough for that notice period instead of their, if there is no work to do?
Yes, I think so. It's not 100% clear from the guidance, but I think so. What HMRC have been clear about in their guidance, one of the few things they have been clear about, is that the furlough scheme can't be used to replace what would otherwise be statutory payments. So you can't, and HMRC are going to be quite sharp, they seem to say, about looking for situations where people are being sort of furloughed as a replacement for redundancy payments. And they'll be keenly checking how long firms stay in business after the furlough scheme stops and whether they've just laid off all the staff just after they've been furloughed. But I don't think from the guidance I've seen, there's anything that would prevent the employer from furloughing during the notice period and reclaiming that money, provided it doesn't replace any of the statutory payments.
Thank you, James. Right, next one, Richard. Do you believe that employers dealing with an employment tribunal claim, providing disclosure or instructions to a lawyer, for example, a HR manager or senior managers, is working for the purposes of furlough? It's not generating an income, but it could be providing services.
Yes, I think it probably is, particularly if it's a senior employer or an HR person providing those kinds of instructions, because notwithstanding that you're not providing services directly external, what you are doing is providing services to your employer. What you're doing is what would be understood to be part of your employment and your duties as an employee. And so, yes, in my view, that would probably fall foul of the terms that mean that you could be in breach of the furlough provisions.
Thank you, Richard. Right, back to Andrew for the next one. Can the EET hold an employee vicariously liable for an act of discrimination of another employee where both employees were not in work or at work at an organised event?
This, I'm going to do what James did earlier and jump on the fence a little, because I think the only answer I can give at this point is possible. And the reason I say that is this: it is entirely context dependent. I think, for example, you might have two employees who are outside of work. They might have been walking to or from work. They may have been talking about work or contacting each other about work, and the act of discrimination occurs during the course of that discussion. It might be that those two employees only met through work, and therefore they were only put in contact with one another through work. So sadly, I think the answer is, to your question, yes, it's possible. It is context specific, but I must admit that if it is truly outside of work, nothing to do with work whatsoever, then I think even before the Supreme Court decisions, you might have had some building blocks for a defence that you're not vicariously liable. I think with the Supreme Court decision, you may well have some stronger building blocks actually to run that argument.
Thank you, Andrew. Okay, the next one, back to James for this one. If an employee returning from maternity leave takes holiday immediately on return, can she be furloughed for that period? Presumably that might cause a difficulty with the minimum 3-week period.
The answer to that, very unhelpfully, is we're not sure. Until the guidance from HMRC is more clear about whether annual leave counts as an interruption of the minimum 3-week furlough period or not, then we don't know. Some people seem to take the view that annual leave doesn't interrupt furlough. Some people seem to take the view it does. I think until we get more guidance on this, I'm afraid the answer is I don't know. And I think if you were an employer, I would take, if you were seeking to furlough, I would take a more cautious approach. But unfortunately, the answer is we don't know until there's more guidance.